Welcome to this explainer. Today, we're untangling a completely wild, landmark case from the Nepalese Supreme Court, involving massive construction contracts, a trail of forged documents, and a staggering 68 crore rupee mystery. If you've ever wondered how the law handles situations where a multi-million-dollar project collapses and everyone starts pointing fingers at everyone else, you are in the right place.
Say you hire a plumber to fix your sink, and they secretly pass the job off to a friend. Do you owe that friend money directly if things go wrong? It sounds like a pretty simple question, right? But when you scale that up to massive national infrastructure projects, the answer becomes an absolute battleground. And this simple concept is exactly what derailed a massive government project in Nepal. Here is our roadmap for this explainer. 1. Project setup. 2. Broken contracts. 3. The subcontractor claim. 4. Legal tug of war. And 5. Final precedent. Let's make sure we understand the exact chain of command before the dominoes start to fall.
Section 1. Project setup for the Dumra-Basi Road. Let's look at how this whole thing started back in 1995. The Department of Roads was the primary employer here, and they had a really massive job on their hands.
To get the job done, the Department of Roads decided to divide and conquer. On one side, you have DBRP-4, the road portion, which was awarded to Rower Construction. On the other side, DBRP-5 involved building 5 separate bridges, and that went to Himal Construction. To keep everything running smoothly, an independent group called Silt Consultants was brought in to supervise the whole operation.
The stakes here? Absolutely massive. Rara Construction's contract for just the road portion was valued at over 4 crore rupees. That is a huge financial commitment from the government. Then you add in Himal Construction's bridge contract, which tossed over 5 crore rupees into the pot. Both of these deals were officially inked in November 1995, and they came with a super strict 21-month completion deadline. The clock was officially ticking.
Section 2. Broken contracts, forgery and failure. Because, well, things went south incredibly fast. The original agreements completely collapsed before the finish line was even in sight.
It was a spectacular disaster. Rara Construction literally got caught submitting forged government documents, what's known as kirte, during their pre-qualification phase. It was so bad, the ministry had to step in and completely revoke their A-class license. And Himal, well, they fared no better. More than halfway through that 21-month timeline, they'd made virtually zero progress. None. So acting on the recommendation of Silt Consultants, the Department of Roads just pulled the plug and terminated both contracts.
Section 3. The subcontractor claim. Enter Gorkha Engineers. With the main contractors out of the picture in disgrace, a totally unexpected wildcard steps into the spotlight. And wow, they do not hold back. Gorkha drops an absolute bombshell, demanding nearly 69 crore rupees in compensation for damages directly from the Department of Roads. Let that sink in for a second. The original contracts combined were worth maybe 9 crores. Now this third-party subcontractor wants almost 69 crores. Insane, right?
Their logic kind of made sense on the surface, though. Gorkha argued, look, Raha and Himal gave us official power of attorney. We were the ones actually in the dirt doing the heavy lifting under the watchful eye of Silt Consultants. They even pointed out that the Department of Roads had issued partial payments based on that work. Essentially, their stance was, we did the job, you own the project, so you've got to pay us.
Section 4. Legal tug of war. Courts versus tribunal. As you can guess, this massive, audacious claim triggers a chaotic legal battle across Nepal. Here's how it played out chronologically. Gorkha demands arbitration to get their 69 crores. In December of the Nepali year 2057, an arbitration tribunal shuts them down, basically saying, you're a subcontractor, you don't even have the legal standing to sue the Department of Roads. But Gorkha doesn't give up. They appeal, and in November 2059, the Patan Appellate Court shockingly flips the script and orders a completely fresh arbitration process to begin. So we have two totally conflicting views at this stage. The Department of Roads is firmly insisting, we never hired you guys. Our contracts were strictly with Rara and Himal. You are a legally irrelevant third party. Conversely, Gorkha and the appellate court are pointing at the actual authorized work that got done, arguing that the subcontractor's rights absolutely demand a fresh hearing.
Well, the Department of Roads wasn't having any of it. They completely refused to accept the appellate court's order. They saw it as a fundamental legal error to reopen a closed tribunal decision involving a third party. So they took it all the way to the top. They filed a writ of certiorari, which is essentially a formal appeal for higher review straight to the Nepalese Supreme Court.
Which brings us to Section 5, Final Precedent. The Supreme Court, the highest court in the land, had to finally untangle this messy web of broken promises, forged documents, and third-party claims.
And they delivered a crucial precedent regarding what's called privity of contract. The Supreme Court essentially ruled that a subcontractor's legal and financial relationship exists solely with the main contractor they directly signed an agreement with, not the original employer. Because Gorkha Engineers only had a contract with Rara and Himal, their entire legal universe is restricted entirely to just those two companies.
The real-world impact of this? It's massive. The court stated that if Gorkha suffered financial losses, they could only claim compensation from Rara and Himal. They were firmly stripped of any right to demand arbitration or compensation directly from the Department of Roads. With that ruling, the Patan Appellate Court's decision was officially overturned, and the government was protected from that 69 crore claim. So, what's the big takeaway from this explainer? Well, whether you're a giant government agency paving a highway or just a homeowner hiring someone to fix a roof, privity of contract dictates exactly where the legal buck stops. Next time you sign an agreement or agree to take on subcontracted work, ask yourself, do you know exactly who is legally bound to pay up when things fall apart? Thanks for joining me on this explainer, and always remember to question the fine print.